Thanks very much for joining, everyone. We are getting into reasonable adjustments in the workplace today, where we're going to delve into some practical insights and strategies to create an environment where everyone can thrive. We will be covering the significance of reasonable adjustments, how to identify, address, and address diverse needs, explore legal and ethical considerations, and share insights into fostering an inclusive workplace culture. Our guest today is Sarah Furness, who is a partner in the employment team at Hay & Kilner and provides advice to employer clients on a range of HR matters. She has an extensive bank of clients across various sectors and is known for her practical and forthright approach. We also have Dr. Jen Cottam, who is a consultant clinical psychologist and founder of TalkWorks. And at TalkWorks, we help leaders build healthy, engaged, and resilient teams through therapy, training, and strategy. So I'm going to pass things over to you now, Jen, and knock my mic and camera off.
Good morning, everyone. Thanks for joining us, and special thanks to Sarah Furness here today, partner from Hay & Kilner. So welcome. We're here to talk about reasonable adjustments in the workplace and to borrow some of your expertise in terms of employment law. So first and foremost, what legislation do employers need to know about when we're talking about ill health at work?
Yeah, the main piece of legislation is the Equality Act 2010, and this act actually covers all different types of discrimination in the workplace. So it sets out the law relating to, race discrimination, age discrimination, and also the law relating to disability discrimination. And the duty to make reasonable adjustments falls within that law and within that piece of legislation. What I would also add is, of course, if you have somebody at work who is suffering from a health problem, you will need to take care in respect of your health and safety obligations. All employers are under a duty to ensure that there is a safe working environment for their job, not job applicants, but for their employees. So it's also being conscious of any impact that somebody's health problems may have on that obligation to ensure that there's a safe working environment.
Okay. And I guess that all sounds like it could be quite complicated for, say, small businesses to understand the legislation and to understand their duty, in respect of health and safety. Where can people go to find out more about this?
Yeah, there's lots of online resources in respect of that. I mean, with the health and safety aspects, usually, there are health and safety organisations out there who can help in respect of discrimination and how to stay on the right side of the law. Then, employment lawyers can support with that, and of course, the team at Hay & Kilner can support with that. In terms of, I suppose, the minimum steps employers should be taking from a discrimination law perspective, I do thoroughly recommend that employers invest time in training their managers. If an employment tribunal was ever dealing with a discrimination claim that had been pursued against your organisation, they would expect as a minimum that employers have invested in training their managers in respect of equality and diversity, which would then cover disability discrimination and reasonable adjustments. So it's really important to think about training and putting in place appropriate policies and procedures, and things like equality and diversity procedures, for example, which again, we can help with. So that's really, I think, the starting point to get some further information.
So starting off with decent policies and procedures, and then also training managers to understand, to recognise diversity, to be able to intervene if somebody is presenting with a difficulty in the workplace that impacts on the workplace. Okay.
Yeah, absolutely. I mean, what I always say to clients is, that this person can be, the best person in the world at doing their job, whether or not they're a lawyer or they're a counsellor or whatever job it is, but to then expect them to step up to being managers without giving the manager the training isn't really fair on them, but it also does create a legal risk from an employment law perspective. And what I don't expect is that, employees or managers would be trained in depth in that they would become discrimination law experts, but they would certainly need training that would almost produce a red flag in their brain or an alarm bell that actually I need to get some support here. I can't just ignore this problem. I need to be taking proactive steps to help somebody. And it's almost just that overview or that realization that they then go, hang on, I need support with dealing with this employee, rather than saying the wrong thing or doing the wrong thing. And in the context of reasonable adjustments, doing the wrong thing is doing nothing.
Right. Okay. So if we think about reasonable adjustments then, and that's a really interesting point, that doing the wrong thing is doing nothing. Yeah. Whose responsibility is that? Is that the employees or the employers or both?
I mean, from a legal perspective, it is the employer's duty to make reasonable adjustments. When I mentioned the Equality Act before and how it governs discrimination law in the UK, you know, it really, in a nutshell, it's, you know, don't discriminate against, you know, your employees and your job applicants on the grounds of race, age, sex, disability, etc. But what it also does is it creates a positive obligation on employers, or it places that positive obligation on employers to make reasonable adjustments. An employee's got to take some responsibility in terms of, you know, communicating with the employer, etc. But ultimately, the legal duty is placed on the shoulders of the employer to take that positive action.
Okay, so the legal duty is placed on the shoulders of the employer. However, it would be also reasonable to expect employees to flag up when they're experiencing difficulties, you know, physical and mental ill health.
It would. I have a lot of clients who ring me and say, somebody's just started employment with us and they're presented with a health problem, and this is the first we've heard of it, and they can get quite animated because it does create a problem for them in their business. Or that they might say, well, you know, we've tried to talk to them about it, but they're not really engaging with us. And so although there is an element of responsibility on the part of the employee to be open and to engage with their employer, at the same time, employers have got to approach this very cautiously, because some employees are reluctant to divulge their health problems because it's very private and personal to them. And particularly with mental health, there is still a taboo. And I suppose, you know, what I would say to my employer clients, playing devil's advocate, is, but if they had told you about these problems, you probably wouldn't have given them the job, would you? And therefore, and they want a job. So it's trying to create that supportive environment where people do feel that they can be open about the health problems, and then the employer supports them in return. So it is a two-way process, but I think employers have got to kind of take the upper hand, if you like. It's, you know, the positive duties on them, and they've got to approach matters sensitively.
And I suppose it's also about creating the culture there that for openness and dialogue about, for instance, mental ill health, and being comfortable with talking about that at all levels throughout the organisation.
Absolutely, and you know, there has been a lot of emphasis in recent years on mental health and on things like the menopause. And the more you feed this into your culture and you create an open culture, the more people will engage with you. The more that people engage with you, the more informed you are, and then the easier it is to help them. Because ultimately, what both parties want is for the individual to be happy at work and to perform well. And you're only going to achieve that by having this open culture and this supportive culture.
Thank you. And in terms of, you mentioned if somebody had mentioned their mental or physical ill health earlier, would you have employed them? Is it okay to ask about mental and physical health at the point of interview or at application stage?
No, and again, this is often what sometimes my employer clients will say to me. You know, they should have told me it as an interview, and we could have helped them sooner. But their employees are under no obligation to provide this information. In terms of when employers can ask the question, it's in very, very limited circumstances. You can ask candidates during a recruitment process if they need reasonable adjustments to help them participate in the recruitment process, and you can ask health questions after you have made a job offer, but you can't ask health questions prior to making a job offer, unless the questions are intrinsic to the job role. So you couldn't say to somebody, for example, in an interview, do you have any health problems? How's your sickness absence record been over the last few years? Is there anything we need to know about? But you could ask them a question if it was very pertinent to the role involved. So I suppose something along the lines of, if you were interviewing a scaffolder, is there any reason why you can't work at height? That would be reasonable. Or if you had somebody who had to do heavy lifting as part of their job role, is there any reason why you cannot carry out heavy lifting? But they've got to be, the questions have got to be phrased very succinctly so that they're very limited to the information that the employer needs to know, and they can't be general questions. It can't be, is there any reason why you can't do this job from a health perspective? It would have to be, are there any concerns which mean you can't work at height or you can't heavy lift?
Interesting. And that's just got me thinking about reference requests as well. So often we'll have reference requests come in from other employers when some of our team members have moved on to other areas, and they'll ask about sickness absence. Where does the law sit on that?
Well, that's the thing, because with the Equality Act, job applicants can pursue discrimination claims, employees and ex-employees can pursue discrimination claims. So if you gave a reference which commented upon somebody's sickness absence record, then you are risking that employee pursuing, I suppose, a disability discrimination claim against you and providing that reference, because if they had a poor absence record because of a disability, then you've ultimately subjected them to a detriment by giving the negative reference, which then means that they don't possibly get the job that they'd applied for. So I would err on the side of caution and not provide sickness absence details in a reference.
Okay, thank you. That's really interesting. You mentioned tribunals there. Is Hay and Kilner seeing any particular trends in terms of discrimination-related tribunals at the moment? Anything interesting of note?
Yeah, I mean, it's very rare that we receive a tribunal claim which doesn't allege some form of discrimination has been committed. What I would say is that it is relatively easy to dismiss employees until they've got 2 years service. So you need, as an employee, 2 years service before you can bring an unfair dismissal claim in the employment tribunal. And employers often think, well, that means that we can dismiss relatively risk-free for the first couple of years, but you don't need 2 years service to bring a discrimination claim. So I guess the trend that we see in answer to your question is that we're seeing a trend of people who have less than 2 years service bringing discrimination claims because they can't bring the unfair dismissal claim. So actually it's not a get out with jail card for employers if an employee doesn't have 2 years service. And I think with now there being such an increase in awareness raised of things like mental health, it does mean that people are more aware of the rights and what employers should be doing to support them.
And if an employee is feeling that they are being unfairly discriminated against at work, what would you recommend to that employee?
I think it depends upon the level of discrimination, because I could say there's a formal grievance process that every employer should have in place, and they should raise a formal grievance. However, that won't necessarily be what the employee wants. I think it's got to be very personal advice to what the employee wants. If it's just that something's happening and the employee wants it to stop, and it might be something that's happening unintentionally, then it can just be an informal word with the person's manager. And a lot of the time employees just want, I suppose, certain behaviours to stop. And the formal grievance route is actually just more stress for them, or they worry then about relationships going forward. So I think the advice has got to be quite personal to the facts and circumstances. But I would certainly say to any employee, you need to speak to somebody as soon as possible. HR, your manager. If your manager is the person who's causing you concern, then a different manager. And document everything as well. I mean, lawyers love paperwork and evidence, so it's document as much as you can, whether it's in a diary or a chronology of events or something.
Okay, so document it and then speak to your line manager or a different line manager in the organisation.
Or HR.
That mechanism.
If you've got HR. Yeah.
Sure. Okay. What do inclusive organisations do well in your experience? You've mentioned training line managers and having great policies and procedures. Is there anything else that great inclusive organisations do well that you see?
Yeah, I mean, I think it's probably back to the culture point, but also making sure that you follow through, I suppose, with what you say that you do. It's okay to have this amazing policy that says, and I do see this a lot, that says we do X, Y, and Z if you don't actually do it. So just follow through on your commitments. Train your managers, as I said, whatever you say you do in your policies, please do it, and just create that culture of openness and support. And then I guess getting back to the topic in hand, make the reasonable adjustments if they are reasonable.
Okay. And how do we determine what's reasonable and what's not?
Yeah, I mean, something that's really important here that we haven't had chance to cover just yet is that in terms of the obligation to make reasonable adjustments, this applies where an employee has satisfied the definition of disability in the Equality Act. So just because an employee has an underlying health problem, it doesn't necessarily mean that they would be considered a disabled employee. And if they're not considered a disabled employee, then the duty to make reasonable adjustments doesn't apply. So the starting point before you get to the reasonable adjustment stage is to actually determine if the person is disabled.
Okay.
And I can go into that in a little bit more detail,
yes,
if
please,
you like.
Great, yeah.
So the definition of disability in the Equality Act is a physical or mental impairment which has a substantial and long-term adverse effect on an individual's ability to carry out normal day-to-day activities. So it's a bit of a mouthful. But in a nutshell, this definition covers physical and mental ill health issues, and the impact of that or that issue, it must last or be likely to last 12 months or more. But also, very importantly, the impairment must have a substantial impact on that person's ability to carry out normal day-to-day activities. So what you need, therefore, is almost to satisfy that definition of disability is that longer-term health problem, which has a substantial impact on your day-to-day life. But when looking at day-to-day life, it's not a question of the employer considering the impact of the ill health on the person's work. It's the impact of the ill health problem on their person's day-to-day life. You know, can they take care of themselves? Can they sleep well? Can they do their own shopping, clean their own house, socialise, exercise? It's those types of activities which are relevant. If they then satisfy that definition of disability, then the legal and positive duty to make reasonable adjustments arises, and that duty falls, as I say, firmly on the shoulders of the employer. So in terms of then, I suppose, whether or not an adjustment's reasonable or not, it all depends upon really the facts and circumstances, of that employer and what's been requested. A tribunal will look at a whole host of different factors, and there's a lot of case law which is giving guidance as to when an adjustment should be considered to be reasonable or not. But every business differs. There probably is, whether rightly or wrongly, more of an onerous duty on larger employers because they tend to have bigger premises with more options. Can you put people on the ground floor or
Sure.
or further up? They do tend to have more resources available to them. They tend to have more vacancies. So if a disabled employee, a job's too much for them, then they should be considered for other roles. So it's all about, if you like, the resources of the employer as well as the impact of the adjustment on the employee. And of course, it's only a reasonable adjustment if it actually helps the employee with the detriment that they're suffering in the workplace. So if, for example, somebody worked 8 hours a day and the reasonable adjustment would be for them to work reduced hours, there's no point in the employer reducing their hours to in most cases to 7.5 hours. The adjustment's got to help.
Okay, so it has to make a significant difference.
Yeah, and again, that's relevant to actually how reasonable it is, because some employers might say, well, yeah, we can shorten the working day, but we can't half the working day because there's too much work to be done. So there's so many different factors, and cost is, of course, important. And tribunals, as a rule of thumb, don't tend to like to rely just on cost as a reason as to why your reasonable adjustment shouldn't be implemented, but it is a relevant factor, particularly for smaller employers.
Are you seeing any increase in neurodiversity claims in terms of disability and tribunals? Yeah. What's that looking like at the minute?
Yeah. I mean, certainly. And again, this is all about, the more you raise awareness and the more you foster a culture in your organisation, I suppose the more you then have these matters to deal with. So because there has been a lot of emphasis on neurodiversity in recent years in the press, there's been various kind of documentaries with celebrities and how they live with it, like Lewis Capaldi and Paddy McGuinness and his autistic children. Then I think all of this creates an awareness, and it means that employers are now becoming increasingly conscious of their duty to support neurodiverse employees. And I think that I've certainly seen a trend with my clients where the government is desperate to get people into work, and individuals will have a support worker and they'll be given a job that doesn't necessarily match their skills or that they're not necessarily able to cope with, and it does cause issues. And it's about thinking about reasonable adjustments clearly and what's reasonable from the organisation's perspective and how they can support this person. And a lot of that is about obtaining the correct advice from the right places. So what I would say about that is often there's a rush on the part of the employer to engage occupational health, and sometimes it's actually better to engage an organisation which specialises in supporting an individual who is neurodiverse, or supporting an organisation, from a mental health perspective, engage an organisation who specialises in mental health support, like a Like TalkWorks, rather than just initially rushing to Oc Health immediately.
So providing the support rather than necessarily rushing in with occupational health assessment.
I mean, occupational health assessment absolutely has its place, but it's not necessarily about it. I think with mental health and neurodiversity, it's often more fruitful to engage an organisation who specialises in supporting individuals with mental health and neurodiversity and engaging them in addition to or instead of Oc Health.
Right. Thank you. Dara, have you got some questions?
Yeah,
for Sarah here. Yeah,
it's been a fascinating chat there so far, and it's just going to give a chance for anyone that's joined the webinar today. If you just want to ask any questions for Sarah or Jen or both, feel free. Your cameras and mics are available if you do want to join and ask a question, or if you just want to pop it in the chat and we can field the questions that way. Whatever works for yourselves. In a second as well.
Just while we're waiting for that to come through, I guess I'm just interested in Hay & Kilner's offering in terms of supporting smaller businesses. Sarah, you and I had a quick catch up earlier where you were letting me know about that. I wonder if you could explain a little bit more to people here. I've just lost you there, Sarah. I've lost your mic. Not yet, no. Plugged in.
Just checking your settings while we're trying to get Sarah's audio back on. Kenny, have you got a question there? I've seen you've come off mute.
I have. Thank you very much.
Brilliant.
So I'm pleased to say I work in a business that has a very open culture around mental health and menopause, all sorts of kind of support mechanisms. I've suffered from anxiety and mental health for probably 20 years, and it's great to work in for a company where I can be completely open about that. It doesn't affect my work life in so much as, I haven't taken sickness at this business as a result of that, because very early on I started to find self-help and support mechanisms for myself to be able to live a normal life, if you like. So my question is, whilst there is obviously the onus on the employer, if recommendation, whether that be from Occ Health or a specialist kind of mental health or neurodiversity support mechanism, suggests that there are things that the employee should be doing to enable them to be able to kind of attend work or things like that. How does that work from a tribunal perspective, in that if that person has not really done those things that perhaps would have supported themselves to be able to continue to do their role, does that come into play?
Yeah, is my microphone back working?
Back on.
Brilliant. I just, sorry about that. I don't know what quite happened. I mean, that's a really good question, and it's something that actually arises a lot in the context of this. And we also see this a lot with employees who are struggling with addiction, like alcoholism and drug addiction. And the employer says, but if they're not, I guess the point is, if they're not willing to help themselves, there's only so much that we can do. This is really difficult to advise on, because ultimately an employment tribunal, there is a level where an employment tribunal will agree that an employer had done enough and that they really couldn't be expected to do anymore. But I think that very much does depend on what the employer has done. What I always suggest to employers is, you just continue with the support, and you continue to, if you like, make the expectations clear to employees in respect of, we expect you to participate in this counselling, we expect you to do these things, and if they don't, then and you've given them ample opportunity to do these things, then I guess at some point the employer has no option but to take steps. And usually this will involve performance management. We're placing you on a performance improvement plan, or we're going to give you some form of warning because of poor performance or poor conduct at work, or a warning for high sickness absence levels. And at some point the employer will just have to go ahead with that process and see where that process ends up, and it might end up in dismissal. And where that point is, I think, depends very much upon what's happened. So, has the employee really tried, but then something's happened in their life, which means that they've been derailed? Has the employer really made it easy for them to take this action? Have they supported them with making sure that they've reduced the workload so they can engage in the counselling? And all of these things become relevant, but it's very difficult to say there's a definitive point when an employer can say enough's enough, but an employment tribunal, in answer to the question, will absolutely expect an employee to take some ownership, if you like, and for an employer to have a point where, look, we've done all that we can do here.
Great, thanks very much.
Is that okay?
Yeah, thank you.
Thank you for sharing that as well, Kenny. It sounds like you're in a good place with reasonable employers just now. I'm glad to hear that.
Yeah, thanks.
Cheers, Kenny. Any other questions for Sarah or Jen? And feel free afterwards, if anything does come to mind, I can share the questions with either. So I'm just going to share some details for you both. And Sarah, feel free to sort of direct anyone towards anything else that you at Hay & Kilner may have happening in the next week or month or.
Yeah, so we do actually have our own seminar dealing with reasonable adjustments, which is, I think, Wednesday, the 20th of September at our offices in central Newcastle. And what we do is we conduct our seminars by way of role play. So myself and other members of the team, we will act out and how to manage reasonable adjustment requests. We also run lots of training, including online training, because we appreciate that it can be quite difficult, particularly for smaller organisations, to dedicate the time and resource to training. So we've got a series of 5 online training sessions coming up, covering topics like equality and diversity, sickness absence management, performance management. So I think the links for those are going to be shared after this seminar.
Thank you, Sarah. Yeah, we'll get those sent out. Jen, is there anything you would like to share from TalkWorks side?
I guess our next webinar series is going to be on EMDR, so understanding a specific trauma-based therapy. So that will be in about a month's time. And we've got our mental health for managers workshop coming up at the end of this month as well, which will be in person. So lots going on. And just to say thank you very much, Sarah. I've really enjoyed talking with you today. Thanks for everybody for joining in.